Okay, so what else do you have on your minds today? Marianne had a cash purchase contingency question.
Yeah, question, it's an offer about ready to go together. It is a cash offer. There is no letter of proof of funds, but I have been told that it should be here from another country within the next couple of weeks. So how do I need to proceed with this? I don't want to lose the sale, but there's no reason that I have to believe that the funds are there, other than they have just said that, which we know doesn't always mean anything.
Okay, so in that instance, and so we've discussed variations on this before, but all these cases are a little bit different. So when you get a situation like that, one of the things, if you're on the buyer side, first of all, was the other agent in our company or from somewhere else? Elsewhere. Okay, well that's good. So I can throw them under the bus more easily. Here's the thing. One of the fundamental advantages to paying cash is 100% certainty because you're paying cash. Well, how do you undercut the bargaining advantage you get by paying cash? Make a cash offer that says, cash offer accept. Except if I can't prove that I've got the cash, that's the basis for the cash offer. I mean, there's no better way to undercut the negotiating advantage of going in with all cash. But what I tell buyers who are getting financing is, you need to use a local, reputable lender with impeccable credibility. And the reason that we want pre-approval letters in hand from local, reputable lenders is because we want sellers, when we're representing a buyer who's getting financing, we want sellers to treat that as being as close to a sure thing as the buyer who gets in a Brinks truck filled with cash and backs it into the driveway. I mean, nothing's more sure than that. Oh, look, there's the pile of cash. They obviously have it. It's sitting in the driveway. Well, the next best thing is a pre-approval letter from a lender that never writes a pre-approval that doesn't show up with the money at closing and that's local, so you know that they have that credibility. So there's this certainty continuum, and the farther toward uncertainty you go, the more you've eroded the bargaining position. So point number one on the buyer's agent side is I would strongly advise against any buyer's agent who has somebody that they think is going to make a cash offer doing it until they got their letter ready to go, because otherwise it's undercutting the advantage of the certainty that a cash offer would normally entail. Now, when you're on the receiving end of what you're on the receiving end of, and we've had other agents in similar situations, unless you have really, really specific, credible information so that you can tell your seller, I really don't have any doubt whatsoever. The other agent, I think that agent is very credible, and that agent had given me tons of detail, so I know exactly what the deal is and exactly why they don't have a letter today. And one example of a situation I ran into several years ago was, post 9/11, there are annual limits on how much can be transferred to individuals via international wire transfer. So I had a situation with a cash purchase where the money wasn't sitting in the bank here, nor could it get here all at the end of that year. It's in December. Somebody wanted to close in between semesters at the U of I. File this under good problems to have. Dad had already capped out on the maximum allowed to be wired into the U.S. for that calendar year, and so they were waiting to complete the purchase with all cash until the beginning of the next calendar year when he could wire a bunch more money in. So I mean, you occasionally will have situations like that where there's tens of thousands of dollars already here. Here's the rest. Here's a statement that's been sent from overseas confirming that it's there and it's available, and here's exactly why it's not here today. So barring a situation like that where you can put all those puzzle pieces together and make a go of it, and in that case get a builder to offer us early possession when we didn't have the money to close yet, short of that, I would just wait. Now when you're on the receiving end of it, if there's anything less than 100% certainty that it's a good deal, make sure you caution the seller. You don't want the seller to turn away a buyer that was legitimate. So you just want to inform the seller and make sure the seller is making the decision. Don't tell the seller, do this or don't do that. Just let them know, here are all of the factors and here's how that bears on the risk of this situation, but balance the risk against you sure don't want to say no to a buyer that could have closed on your house in 2 weeks because we were just a little too skeptical and or rude about it. From a marketing standpoint, if you choose to execute or your seller chooses to execute a sales contract on a cash offer, the correct way for that to be done on the buyer's agent side is it needs to be cash offer with contingency. Again, bad idea ever, pretty much, to do that, but if they're going to do it and they don't have the proof of funds right now, it needs to be cash offer with the contingency. And there's an MLS form for that contingency where you put in that the proof of funds will be made available no later than such and such a calendar date. So the buyer's agent needs to make sure they have that. The consequence if they don't is we can't force the person to close on the purchase of the house if they don't actually have the cash. So that isn't really the issue. The issue isn't whether you could sue them and get specific performance, because if they really don't have the cash and we're misrepresenting, you can't make them close. The issue really is, can you sue them for damages? Because in the case of a financing contingency, they have an out. We tried, we made a good faith effort, a diligent effort is what the contract says, and we were unable to obtain the financing that we described in this paragraph in the contract. If it is just a cash sale, no contingency, and they don't close for any reason, unless they've exercised something in the inspection contingency, they are liable for all of the damages. And presumably, in most cash deals, you'll see larger than average earnest money checks. So there usually is at least some larger than average sum of money already at stake. So keep in mind that's the distinction. Now, as a practical matter, let's say you have that offer, it's cash, it has the proper contingency, it's on the MLS form, your seller is comfortable with the date, they know that it'll be a couple of weeks before we know if it's really a sure thing, but once you've executed that contract, you have an executed contract. So now your listing is encumbered by a fully executed contract subject to contingencies. No different than if it were subject to a financing contingency or an inspection contingency. But the bottom line is it is still a fully executed contract that now encumbers the property. As soon as that becomes the case, you cannot have it as active. It must be either pending or moved to K status, because it becomes unethical and illegal to market it as being 100% unencumbered, which is what active status means, when in fact it is encumbered by a fully executed sales contract. So that's another one of those risk-reward conversations to have with your seller. And probably the easiest way to mitigate that is going to be to tell the seller, if you have made the decision to accept this so we don't let them get away, we also want to assume the worst. What if it doesn't pan out? How do we mitigate your damages right now? And the best way is to try to make sure we keep it on the market as much as we possibly can. And so to that end, Mr. and Mrs. Seller, I'm going to recommend that we put it on a contingent status. I can't have it as active because it's now encumbered by a sales contract. This contingent status will let it continue to go to all the consumer websites, so Realtor.com, Trulia, Zillow, Remax.com, all those sites will still show your listing. Now, we all know, as a practical matter, when we see something that's K status, what do we tend to assume? I didn't hear any of that, but I'm assuming that they were all variations on, it's already sold, it's a short sale, it's got a contract subject to third-party approval. One way or another, it's not really available. Be sure if you put it as K status, and the most annoying thing about K status is when an agent does it and then it's just call listing agent. Well, that's helpful. I mean, what that means is if I'm busy, and especially if it's a notoriously hard to reach listing agent, I'm just not going to put it on the show list, because 9 times out of 10 it means it's already spoken for, and what I'm going to be told is you're going to be a backup offer. So in the case that we're talking about, where there really is a good chance that based on, on all of the factors you're considering, there really is a good chance it may not come together, make very certain that you put something in the agent remarks that says, we have an offer with funds coming from overseas that have not arrived yet, or something along those lines, please continue to show. I mean, put something in the agent remarks if you're going to go to the trouble of putting on a K status because you really think there's a good chance or a better chance than not that the next buyer that comes along won't just be stuck in backup position. Put something in there to let them know. Yes?
So the next day, another cash offer, local comes in.
You're forced to wait until that contingency date to kick the first buyers out.
Okay, and where does the contingency date come in? Where,
Sure. I'll pull it up.
Oh, well.
So this is among the easiest of the forms to fill in because it's really simple. I mean, there's one date here, right there, that's it. I mean, one deadline. That's the date when it's signed, but one deadline, that's all. So make that as tight as you need to, but be aware if you've been told already, here's the reason we don't have it today, we need 2 weeks, and if it's 2 weeks, you really are just locked out for 2 weeks. You can't do anything to initiate termination of that contract until that 2 weeks is come and gone. So for those 2 weeks, anyone else who shows up really is in backup position. Now, in most cases, you're in a really good spot if you're getting multiple offers coming in within a period of days, especially in the off season. So the bigger issue is you don't really want it to go pending, drop off of all of these consumer sites and then go back on and have the stigma of a fall through. And then, of course, the question is, what happened? What's the matter with the property? What's wrong? When it really was, nothing's wrong. I mean, I've lost count of the number of times over the years post fall through, you see an agent having to put something on, slightly desperate sounding in the remarks. It fell through all of those other times because of bad buyers, not because it's a bad house, and it sounds so sad. But the house has obviously been stigmatized because it, was sold and then unsold. So don't put up any sold signage, put it as case status, and keep in mind that you may also still be able to generate leads. Be really upfront, say right off the bat, I need to let you know this has a sales contract on it. There's a reason we're still allowing it to propagate out to these consumer websites. Here's the status of it, and here's why we are basically sitting tight and letting it stay marketed for another couple weeks. Any other questions? Because that really is a good one, and it comes up pretty often.
Not a question, but just a comment. Since part of my past history is working in a trust department, there are some instances where this form would work particularly well if your buyer was expecting to get money from a trust. The trust officer would need to say, yes, the funds are available, and they would be the ones who would do the letter rather than the banker saying the funds are there. There might be...
I would still encourage people to get their ducks in a row before they make their offers.
Right.
But
there's there may be securities that need to be liquidated in order to have the cash available. And so there could be some very valid reasons for using this form, and I don't find it scary at all.
In other words, you're not liquidating it until you actually have the property picked out. No point liquidating it earlier.
Right.
Yeah, that's a good point. But if that's the case, then be prepared to explain it and probably show as much of a paper trail as you can. Or ideally show if the trust isn't there for privacy/paranoia reasons, then get some sort of a statement showing the value of the securities that are being liquidated to make the purchase, so that there's enough puzzle pieces so that if you're on the seller side, so that by agreeing to that contract with this contingency in it, the risk is really minimal because they have the assets available. The assets can be liquidated on demand in the case of marketable securities, and so it really is just a matter of having this trust officer execute these various steps. But nonetheless, for the next week or 10 days or 2 weeks, there's a contingency in place because we don't have it as cash sitting in a checking or money market account today. That's a really good point.
Another way of thinking, whether this be right or wrong, if it's a cash sale, no contingency, you get a $10,000 earnest money check, they default. Well,
what happens?
You said something about being able to sue for damages.
Right.
Well,
you don't get the earnest money automatically, though.
Okay.
So we don't have any provision for liquidated damages whereby the earnest money is automatically forfeited. It's just that you've got this old adage that possession is 9/10 of the law, and that buyer no longer has possession of all those thousands of dollars. So it gives you leverage, and it can be, we're not going to sign, rarely are these sorts of things going to get litigated. One of the reasons that those situations aren't going to get litigated is if you know that it's a buyer who you can't possibly get to perform. They're making it all up, or they did have money and something happened, they had a wild night at the Riverboat Casino or whatever, and there's simply no way they're going to be able to close on that property no matter what you do. So suing them isn't going to change that. Suing is just going to determine damages and whether you can extract damages from their hide. Problem is, if you were going to try to sue for a specific performance, you get into the situation where you're suing, alleging that there's still a valid contract that you're seeking to specifically enforce, which means if that isn't successful, you can't simultaneously sue for specific performance and put the property on the market as being unencumbered when the whole point of your lawsuit is we're under a valid contract. So it creates a whole other set of complications. So that is one of the many reasons why in the desire to mitigate damages, you're gonna want to find the fastest path to back on the market. So now you may find a deal that's going to sit in purgatory for a while, in which case you want to get it back to case status right away, but say in the agent remarks, so that we avoid the assumption we all have with case status of I'm going to be relegated to second place, say we are just awaiting final disposition or termination of previous contract, please bring offers. And in many cases, you may have a situation where there's legal wrangling going on and the position of the seller who has been damaged by the buyer's default, the damages suddenly are much, much less than the seller had thought if they're lucky enough to have another offer that shows up a week later. And if that's the case, the seller may suddenly go from holding off signing a release that returns the earnest money or returns more of the earnest money than the seller was inclined to do, to let me get that release executed really, really fast so I'm not forced to make this new buyer's offer subject to a bunch of other prerequisites. So you get into a lot of really complicated situations. You have to make sure you have an attorney in those situations. And remember, the attorney is not expert in what our obligations are with respect to the MLS rules, nor with respect to just our Code of Ethics Marketing and Real Estate License Act obligations. So you've got two distinctly different concerns. You always want to have an attorney involved anytime you're trying to bail somebody out of a contract to protect your client. But from our standpoint, if you have questions on what should I do next to mitigate the damages to my seller to make sure it's getting marketed to the greatest extent I possibly can without running the risk that in the case of the Bill Mitchell example that I've cited a few different times with his permission, he put it back on the market only after he knew without a doubt that it was dead and there was no possible way those people were closing because they'd been turned down by 5 different lenders. And then a month later they're under contract with a new buyer and the first people get Bank of Grandma who says, yes, I'll loan you the money. And then they've got the property promised to 2 different people, and a settlement has to be paid out. So, you always want to balance that, get it on the market as much and as effectively as you can, but mindful of whatever encumbrances that property still has.